Welcome, everybody, today to AARP's session on legal issues for seniors. So this session is going to cover estate planning, wills and trusts, power of attorney, and reverse mortgages. Today, we are lucky to have Tim Lenaghan be our speaker on these issues. Tim is a staff attorney at Legal Aid of Nebraska in the Omaha office. He has been with Legal Aid for 5 years. He also teaches a course through UNO's Department of Gerontology titled Legal Aspects of Aging. Tim is an Omaha native. He received his bachelor's degree from Marquette University in 2009 and his law degree from the University of Nebraska College of Law in 2013. He is married to his wife, Laura. He has 2 children, a 5-year-old daughter, Kate, and a 3-year-old son, Hank. In his free time, Tim enjoys being a dad, spending time outdoors, and cheering for his favorite teams, in particular, the Marquette men's basketball program. So here we have Tim, and he will lead us in the session.
Thank you, Mike. I'm going to go ahead and share my screen here and pull up my PowerPoint. Okay, and thank you again, Mike, for the introduction. As Mike mentioned, my name is Tim Lenaghan. I'm an attorney with Legal Aid of Nebraska. I'm a staff attorney in the Omaha office. I also teach a course at UNO it's actually an online course through UNO called Legal Aspects of Aging. So I cover a lot of these same topics in my class. If anybody's taking any classes through UNO, you can look for my course. I'm always happy to have people join. So just to give you a little bit of background about the organization that I work for. Legal Aid of Nebraska is a not-for-profit law firm that provides legal services to low-income and older Nebraskans. We serve about 1,800 people, 60 or older each year. And we primarily do that through our Elder Access Line, which is a free legal hotline for anybody who's 60 or older, where we can provide free legal advice, and we also provide simple forms, including some of the things that we're going to cover today, like powers of attorney. The Elder Access Line is the senior-specific program that Legal Aid of Nebraska has. Legal Aid of Nebraska is located, my office is located in Omaha, and so is the Elder Access Line. But we serve every county in the state of Nebraska. We're open every weekday. The hours vary a little bit. So if you are interested in getting help from the Elder Access Line, please do check our website. But what we do is it's a free legal hotline that provides legal advice in simple forms for anybody who's 60 years of age or older. Unlike most of Legal Aid's other programs, we do not have income or asset restrictions for the Elder Access Line. The only qualifier is that you are 60 years of age or older. The Elder Access Line and Legal Aid of Nebraska, we only deal with civil legal issues. We do not deal with any kind of criminal issues. So if you rob a bank, do not contact Legal Aid of Nebraska. We are not the kind of law firm that you need. And another important point is that when somebody calls Legal Aid of Nebraska and wants legal advice, the legal issue must be the caller's, or we need permission from the person whose legal issue it actually is to speak to a third party. So sometimes we have adult children who call in with their parents or call trying to get advice for their parents. And we say, this is actually your parents' legal issue, so we need to talk to them or at least get their permission to talk to you and provide legal advice through you. So that's just one important point I like to tell people, because we do get those calls quite a bit saying, I need help from mom or I need help from my dad. And we say, no, we actually need to talk to mom or dad before we can actually provide legal advice for them. So today's session, we are going to cover about 4 different major topics here. We're going to cover the power of attorney, the financial power of attorney is what I like to call it, because it differentiates it from the healthcare power of attorney. So we'll cover the financial power of attorney in forms where you can get the power of attorney document to fill out. We'll also cover the living will and the healthcare power of attorney. Now, those are 2 distinct concepts, but I do cover them together because they both have to do with healthcare decision making. So it makes the most sense to tackle those together. We'll also talk a little bit about estate planning, about what to do with your property as you're thinking about, who do you want your property to go to when you pass? What do you do with your property beforehand? Some of those kind of issues all tied into estate planning. And then I'll also cover reverse mortgages because we see a lot of people who call in the Elder Access line and ask questions about reverse mortgages. They're not really sure how they work. It's a little different from your average conventional mortgage. So I also cover a little bit of that for you. So starting off here with the power of attorney. A power of attorney is a legal document that gives another person the authority to manage your financial affairs and make decisions about your property. So what you're doing is you are giving somebody else the legal authority to act on your behalf with regard to your financial affairs. Okay. People get confused about this concept. They think that they're giving away their rights to make their own decisions. No, what you're doing is you are assigning somebody else to manage your financial affairs for you, make decisions about your property. But so long as you have capacity, you can always dictate what your power of attorney is allowed to do on your behalf. So as a common example, what we see most often is adult children. Maybe mom or dad isn't doing so well health-wise. They can't make it to the bank anymore, or for one reason or another, they cannot manage their own finances very well. What they'll do is execute a financial power of attorney, and they will appoint the adult child to act on their behalf and do essentially their banking for them, or deal with other aspects of their financial life, acting on behalf of their elderly parent. So that's the most common example we see is adult children being appointed to be the power of attorney for their parents, and they just end up doing kind of the odds and ends, banking, paying bills, maybe talking to Social Security, but just acting on behalf of their parent with regards to financial matters. So that's what you're doing with the power of attorney. You're just giving somebody else the authority to act on your behalf with regard to your financial affairs. So in some of these terms, these are the legal terms that go with the financial power of attorney. The principal is the person who signs the power of attorney document, is the person who's giving their authority to another person to act on their behalf. The attorney, in fact, is really an agent. It's the person who's receiving authority from the principal to act on the principal's behalf with regard to their financial affairs. In Nebraska, we have two different kinds of powers of attorney. There is the durable power of attorney and the contingent power of attorney. And what I mean by durable power of attorney is the agent's authority is exercisable notwithstanding the principal's subsequent disability. In Nebraska, these powers of attorney are presumed to be durable unless they state otherwise. So what does this mean? So what it means is when the principal gives the agent authority to act on their behalf, the agent is going to continue to have authority to act on behalf of the principal, even if the principal becomes incapacitated later down the road. So that's why we tell people you can't, a principal cannot execute a valid power of attorney document in Nebraska unless they have the capacity to do so. So if somebody becomes incapacitated and they do not have a power of attorney document, they cannot execute a power of attorney document until they regain capacity. And if they don't regain capacity, then you're talking more about like a guardianship, but we won't get too deep into that. But what you should know is that when you exercise a power of attorney document in Nebraska, it is presumed to be durable, meaning that if the agent or if the principal later becomes incapacitated, they're in a car accident in the hospital, or they have severe dementia or something, they become incapacitated for whatever reason, the agent still maintains the authority to act on behalf of the principal. Okay. There's also what's called a contingent power of attorney in Nebraska. And what that is the agent's authority doesn't kick in until a given event happens. So it could be a date, it could be a certain condition. We don't recommend that people do contingent powers of attorney, and the reasoning is that what you're doing is you're giving somebody else the ability to manage your finances, manage your money. If you don't trust somebody to do it, if you trust somebody to do it now, it doesn't make sense to make it contingent upon some other event occurring or some other date. You either trust the person to act on your behalf or you don't. So what we do at Legal Aid of Nebraska and the Nebraska Supreme Court forms for powers of attorney, they are all durable. We don't mess with the contingent ones, but it is possible to make a contingent power of attorney document. The durable one just makes most sense. It's a cleaner process to just make it a durable one. So that's what we stick with at Legal Aid of Nebraska, and that's what the Nebraska Supreme Court forms are also designed to be, is the durable power of attorney. So most, if not all, of the powers of attorneys I've ever dealt with were durable. So moving on here, how do you execute a power of attorney document? A power of attorney document must be signed or acknowledged by the principal in front of a notary public. So it's got to be notarized. The signature of the principal, who's the person giving away the authority to manage their financial affairs, that signature needs to be done in front of a notary public. You got to have it notarized. If the principal can't sign the document for whatever reason, he or she may direct another person to sign on his or her behalf, and that signature must be acknowledged by the principal in front of a notary public. So you're going to have a notary involved. So a power of attorney document takes effect when it is signed, unless it says differently. If the power of attorney document becomes effective on a contingency, you can authorize somebody else to say when the contingency has occurred. Again, we don't deal with contingent powers of attorney at Legal Aid of Nebraska. We stick with just the durable power of attorney. It makes more sense. You have the principal execute it in front of a notary public, and then the agent has the authority to act on behalf of the principal, even if the principal becomes incapacitated later on. So just an easier way to go about it. We don't mess with the contingent powers of attorney. So when does the power of attorney, when does the agency relationship end? Well, a power of attorney would end upon the death of the principal because there's nobody to act on behalf of anymore. It ends if the principal revokes the power of attorney document, and that's a very simple process, just a one sentence. We actually included in all of our power of attorney documents, I hereby revoke any and all powers of attorney documents previously executed by me. So it's a very simple process if you want to revoke a power of attorney, but that upon revocation, the execution of a revocation document, the agent would no longer have authority to act on behalf of the principal. If the power of attorney document provides that it terminates upon some stated event or time or whatever, then the agency relationship would end and the agent would no longer have the authority to act on behalf of the principal. If the power of attorney document is created for a specific purpose and it's laid out in the document, and the purpose of that power of attorney document is accomplished, then the power of attorney relationship would end. Or if the agent dies, becomes incapacitated, resigns, and there isn't an alternative power of attorney agent listed in the document. So subsequent powers of attorney. So the execution of a power of attorney document does not revoke a previously executed power of attorney document unless the new one provides that it revokes the old one. So in the forms that we use at Legal Aid of Nebraska, we have a statement in there that says, I hereby revoke any and all power of attorney documents previously executed. So just to make sure that there's no question about which document's going to be valid, all of ours say we're going to revoke any and all previously executed documents. So with a financial power of attorney, you can have co-agents. So you can appoint two people to manage your financial affairs on your behalf. We don't really recommend that people do this, but it is a possibility. And if you do name two people to be agents at the same time, unless the power of attorney document provides otherwise, each co-agent may exercise authority independently. And with this is where you could kind of run into an issue. If you have two people who are appointed in a power of attorney document to be agents for somebody, they can both exercise their power individually. They can go do things. They could do conflicting things. And if the principal is unable to resolve them, then you could get yourself into a tough situation. So what we recommend that people do is just name an alternate, name a primary and a backup agent. That's what we tell people to do. Pick one adult child to be your primary agent, and then maybe pick another adult child to serve as the backup in case your primary agent cannot act on your behalf. So if the primary agent dies, becomes incapacitated, or just declines to serve in the agent role, then you've got the backup already named and in place. You don't need to execute a new document. So we just tell people, pick a primary agent, somebody who's going to be acting on your behalf, and then pick a backup just in case that primary person cannot do it for whatever reason. And the principal can actually designate more than one successor agent. So you can have a primary and then a backup number one, and then a backup number two if you want to, or on down the line. But we tell people it makes the most sense just to say, this is going to be my primary. If my primary can't do it, here's my successor agent, my backup agent. Just makes it a little simpler. And most of the time, people only need one or two agents in their entire lifetime, if at all. So we just recommend that people do one successor agent if they're going to do it. And we try to tell people to stay away from the co-agents just because they can kind of get messy. And your successor agent is going to have the same power as the original agent. So they'll just step into the same role that your original agent was performing, just steps into their shoes and does manage financial affairs on behalf of the principal, just like the first named agent would. So in Nebraska, the following powers must be expressly granted in the power of attorney document. So these are what we would consider kind of the hot powers that you can give to your agent. And what all of these have in common is that they can change what the estate of the principal looks like when they pass away. So if you notice these things, your agent's ability to create, amend, revoke, or terminate a trust, to make a gift of the principal's property, to create or change rights of survivorship, to create or change a beneficiary designation, to delegate authority under the power of attorney document itself, to waive the principal's right to be a beneficiary of an annuity, including a survivor benefit under a retirement plan, or to renounce the property of the principal. So what all these have to do is they can change what a person's estate will look like when they pass away. And so the legislature has decided that these powers must be expressly given and expressly acknowledged by the principal. The principal has to actually put their initials next to each of these powers if they want to give these powers to their agent in the document. So they must specifically choose and note on the power of attorney document that these powers are going to be given to their agent. There's a general grant of authority that says, hey, my agent is allowed to manage my financial affairs for me. And then these are this is the specific grant of authority. These hot powers would actually have to be individually selected if you want to give your agent that authority. So again, the one thing these have all in common is that they could change what the principal's estate would look like when they pass away. And so the document itself must be very specific about whether these powers are going to be given to the agent or not. So how do you create the financial power of attorney document? Legal Aid of Nebraska, we've got through our website, you can get the forms. So we have a program called Law Help Interactive. What you can do is go through there. That'll ask you questions. You can put your information in there, your agent's information, their name, their contact information, their address, and they'll ask you which powers you want to give to your agent. And then after you've answered the questions, it will actually generate the documents all filled out for you. And then all you got to do is print it and then go sign it in front of a notary, and you've got yourself a valid power of attorney document. So that's one way to do it. For the less tech savvy, if you kind of just like doing the working with just paper, you can contact the Elder Access Line, and the number's down there, and it's also available on our website. And our paralegals can talk to you about what a power of attorney document means, and then they can send you the forms, including instructions for filling out the financial power of attorney. So you can get it for free through Legal Aid of Nebraska through our Elder Access Line. if you are interested in executing a power of attorney document. The forms are also available on the Supreme Court website, but we just tell people, contact us here at Legal Aid. If you are 60 years of age or older, call the Elder Access Line. You can get a little bit of advice. If you have questions about the power of attorney document, our paralegals are excellent. They can explain to you what the power of attorney document means, much like I'm doing here today. And then they can send you the forms that you need, and they can get you the instructions as well so that you can fill it out and have a valid power of attorney document. So once you've created your power of attorney document, what do you do with it? People ask me that. We tell people, keep the original or a copy. A copy is as good as the original. You can give a copy to your agent so that they can, take it to your bank, and your bank can make it part of your personal file there. And so they'll know that you have a power of attorney who's been appointed to manage your financial affairs, and they'll deal with your agent. Some financial institutions and some government entities as well may require that the principal, they may accept a power of attorney document, but they may also have individual institutional requirements, like having consent forms filled out. So you may need a power of attorney document and like a consent form from a bank or Social Security. I know Social Security will not talk to an agent just with the power of attorney document. The principal actually has to fill out a separate form so that Social Security will actually deal with your agent. So they make you jump through some hoops. No surprise there with the federal government, but just know that your financial institution may have their own rules and requirements, and they may require you to fill out a separate form as well. But a lot of banks will just accept a financial power of attorney document as long as it's validly executed. What you can do, you can give a copy to your bank, like I mentioned, they'll put it in your file, and you can also give a copy to a trusted family or friends. You just want to make sure that when the power of attorney document is actually needed, somebody can get access to it. Okay, don't put it in the safety deposit box unless you have somebody else who's able to get into that box, because you don't want to end up in a situation where you need your power of attorney document, but nobody can get to it. So that's what we recommend that people do. So moving on, just kind of to recap. So the financial power of attorney, or the regular power of attorney, what you're doing is you are appointing somebody else to manage your financial affairs on your behalf. The healthcare power of attorney in the living will has to do with making healthcare decisions for somebody else on behalf of the principal. The living will is a concept that a lot of people mix up with the healthcare power of attorney, and really this is the only part of the presentation where I'll talk about the living will. It's just this slide here. So what the living will is, also sometimes called an advance directive. It is a statement about the kind of care that you want to receive if you are terminally ill or in a persistent vegetative state and you are not expected to recover. So it's just a statement of the kind of care that you want to receive if you are in this specific circumstance here. So if you're terminally ill or in a persistent vegetative state and not expected to recover. Okay, it's just a statement of the kind of care you want to receive if you're in that situation. And the two components of it are, the two care components of it are whether you want to receive artificial nutrition and hydration, and if you want to receive artificial life-saving measures like being put on a ventilator, for example. So it's really just saying, hey, if I'm in a persistent vegetative state and not expected to recover, I want to receive artificial nutrition and hydration, and I want to receive artificial care as far as a ventilater, that kind of thing. So think of the Terry Schiavo case. This is the example I use in my course. Terry Schiavo was a case from the late 90s, I think. I do remember it from my childhood. I know it went all the way up to the Supreme Court, but it was a case about advance directives. And I believe that Terry Schiavo had not executed a living will. But after the Terry Schiavo case went to the Supreme Court, every state kind of looked at their statutes and said, do we have a provision in the statutes that allows for a living will? And what are the rules going to be for living wills in these states? But in Nebraska, there's a specific statute that allows for living wills, and it's the statement of the kind of care that you want to receive if you were in the situation that Terry Schiavo was in. She was in a persistent vegetative state. She was not expected to recover, and there was a question about whether she should continue to receive the artificial nutrition and hydration and the life-saving treatment to keep her alive. It was to keep her on a ventilator. So that's all a living will is a statement of the kind of care that you want to receive when you are in that very specific Terry Schiavo circumstance, okay? That's what a living will is, or an advance directive. That's what they're talking about. Just a statement of the kind of care that you want to receive in that specific situation. Now, a healthcare power of attorney is like the financial power of attorney. What you're doing is you're designating another person, the agent, to make healthcare decisions for you if you are unable to do so. That's the big thing. The two big differentiating aspects of the financial power of attorney and the healthcare power of attorney is that one is about financial decision making, one is about medical decision making. And with the financial power of attorney, as soon as you execute the document, your agent can act on your behalf with regard to your financial affairs. You can execute that power of attorney document, and immediately your agent can start acting on your behalf with regard to your finances. When you execute a healthcare power of attorney document, your agent does not have the authority to make healthcare decisions for you until you are determined to be incapable of making healthcare decisions for yourself, okay? So you are not giving another person the right to overrule you with regard to making your healthcare decisions. You are just appointing somebody to make healthcare decisions for you in the event that you are unable to do so yourself, okay? So what needs to be in a healthcare power of attorney? What are the contents of a healthcare power of attorney? Well, the healthcare power of attorney must be in writing, it must be a document. It must identify the principal, the agent or attorney, in fact, and the successor agent, if there is any. It must specifically authorize the agents to make healthcare decisions on behalf of the principal in the event that the principal is incapable of doing so themselves. It's got to show the date of execution, and it must be executed in one of two ways here. It must be witnessed and signed by at least two uninterested adults, meaning two people who are not named in the document itself, so not the principal or the agent. Or the other way you can execute it is to sign it before a notary public who cannot be the agent, in fact, or the successor agent. So you can execute it in one of two ways. You can have two disinterested adults act as the witnesses and sign the document. That's a valid power of attorney for healthcare. Or you can execute it in front of a notary public, have the principal sign in front of a notary, just like you did with the financial power of attorney. So who cannot be your healthcare power of attorney? So there's a statute in Nebraska that says who is not allowed to be your healthcare agent. So your doctor cannot be the person that you name to make healthcare decisions for you in the event that you cannot do so yourself. Your doctor's employee cannot do it unless they are related to you. An employee at a nursing home or assisted living facility cannot be your healthcare agent. And then this is the most interesting one, a non-relative who is a healthcare power of attorney for more than 10 people. Now, I cannot imagine who in their right mind would want to be the appointed agent to make healthcare decisions for 10 people or more. So the legislature decided that they were going to cap how many people that you can be a healthcare agent for at 10 people. So a non-relative who is the healthcare power of attorney for more than 10 people cannot be your agent. So that is the cap, 10 people. I don't know why you'd want to make healthcare decisions. It's hard enough to have to make healthcare decisions for one person. I couldn't imagine being the appointed person to do it for multiple people. So that was an interesting little tidbit from the statute. So when does your healthcare agent have the authority to make decisions? Your agent has the authority to make healthcare decisions on your behalf when you are determined by your doctor to be incapable of making them yourself. So it is a decision that your doctor has to make. They have to say, okay, this person is no longer able to make their healthcare decisions. Do they have a healthcare agent? Do they have a healthcare power of attorney document? Yes. Who's their agent? Okay, I am making the determination this person cannot make their own healthcare decisions. So this agent is now going to have the authority under the healthcare power of attorney document to make healthcare decisions for the principal. So how do you create one? Just as we did with the financial power of attorney, Legal Aid of Nebraska has Law Help Interactive. You can do it online, or you can contact the Elder Access Line, and we can talk to you about what a healthcare power of attorney means and then send you the forms that you need to fill out with the instructions. So you can do it just the same way that you would with the financial power of attorney. And Legal Aid of Nebraska, our forms are our healthcare power of attorney forms include living will language. So if you want to do a living will, you can do that within your healthcare power of attorney. If you want to have that statement about the kind of care you want to receive if you're in the Terry Schiavo type situation. They don't have, those two things do not have to be together, the healthcare power of attorney and living will, but it makes sense to us because they both have to do with your healthcare decision making. So just put them into one document and make sure you've got all of your wishes healthcare wise in one document. So once you've created your healthcare power of attorney and living will, what do you do with it? Again, keep the original or copy in a safe place. Give a copy to your agent. One point about healthcare power of attorneys. So you cannot have co-agents with a healthcare power of attorney. I think it's pretty clear to see why, is because you don't want to run into a situation where two people are appointed to make healthcare decisions and they disagree about a course of action. So in Nebraska, you can name successor agents, but you cannot have co-agents with the healthcare power of attorney document. You can also give a copy of your executed document to trusted family and friends. And the most important one I tell people, give a copy to your doctor. They will make it a part of your medical file. And then anybody who accesses your medical records can see that you have a healthcare power of attorney if needed. So they can make it part of your medical file. So that's what you should do. The most important thing, I think, is to put it in your medical record. So moving on to estate planning here. So we're going to talk about two aspects of estate planning, wills and trusts. The last will and testament, I think everyone's heard of and probably has an idea of what it is. What you're doing with a last will and testament is stating who gets your stuff when you pass away, and who is in charge of making sure that your stuff gets to the people that you want it to. So you're going to have the personal representative, the person that you've appointed under the will, to distribute your property as you see fit to your beneficiaries, the people that are going to get your stuff. So a trust document creates a legal entity that determines how trust property is distributed. I'm not going to go, there's multiple kinds of trusts. I'm not going to get too deep into it. We're just going to kind of cover the basics of estate planning here. Okay. So what happens if you die and you have not executed a will? Well, in every state, there's what's called the intestate succession statutes. It's a hierarchy of who gets your property after you pass away. First, they look to a spouse, then the statutes will look to children, then they will look to parents, and it's a statutory scheme that distributes property according to kind of a step-by-step process of who they look at for getting your property. So if you pass it without a will, there is a backup. The intestate succession statutes are followed. And the people that are actually inheriting the property of the deceased are considered your heirs. Okay. I had a property professor in law school who liked to say, he'd make this joke about you can't have any heirs until you die because they're not really your heirs until you are deceased. It's law professor humor is just something else. But the people that are your heirs are the people who are receiving your property upon your death. They don't become heirs until you die. So probate, maybe you've heard of the term probate or had experiences with probate court. So what probate is a court action that distributes property pursuant to a will or intestate succession. In Nebraska, we have an actual probate court. It's a specific court that deals with probate issues like wills and trusts. Probate court also deals with guardianships and conservatorships, but we won't touch on those today. But what it is it's a specific court that distributes property pursuant to a will or intestate succession. So when somebody passes away, you file a petition with the probate court to open an estate for the deceased, and then you file the will. If somebody doesn't have a will, then you follow the intestate succession statutes. So you must file a case with the probate court when the estate contains real estate valued at more than $50,000, or personal property worth more than $50,000. So you do not have to file a case in probate court if the person's estate will contain less than $50,000 in personal property or real estate. And what you're doing when you're filing in probate court is it's a court process that allows debts, the oversight of a judge to see that the debts of the deceased are paid and the remaining assets are distributed according to the will or the intestate succession statutes, if that's the situation, if somebody dies without a will. So it's a court process. If you die without a lot of property, your estate does not need to go through probate. There are other avenues of transferring property following the will. It's not overseen by the judge. But if you've got a high valued estate, your estate will be overseen. The distribution of your estate will be overseen by a judge, a probate judge. So some of the informal options of getting rid of your stuff. Of course, you can always gift your property while you're still alive. If you want to, give family heirlooms or any property really that you want, you're allowed to give it away. Once you've given it away, somebody else takes ownership of it. You no longer have a legal interest in the property. It's not part of your estate when you pass away. Another way of distributing your property while you're alive, you can name beneficiaries on accounts. You can do that with bank accounts, life insurance policies, there's some other financial instruments that allow you to name beneficiaries. I think 401ks and investment vehicles, you can name beneficiaries. So somebody, upon your passing, your property will pass to those beneficiaries outside of a will or a trust. One thing we see a lot of is somebody says, hey, I want to give my property to my children. I'll give it to them in my will. We say, no, the best way to do it is to do a transfer on death deed. And what you're doing is you execute a deed that will not actually transfer the property to another person until you actually pass away. So this is what we recommend that most people do because it'll take effect as soon as you pass away. Excuse me. And you can avoid the probate process. So the transfer on death deed is a great vehicle for most people. You can execute it while you're alive. You can have surety that whoever you want to get your house is going to get your house as soon as you pass away. You execute the transfer on death deed. You file it with the recorder's office. Once you pass away, whoever's going to get the title transfer to take your birth certificate, your death certificate to the recorder and show that you passed away. And at that point, you would then have title to the property. Another thing that you can do is you can add co-owners to bank accounts. Now, this may seem like a good idea. So say you're an older person who wants to give the money in an account to your children when you pass. So you go and you add them as a co-owner of the account. That can be fine as long as you really trust your family member. Because once you've added a co-owner to account, all of that money instantly becomes as much theirs as it is yours. So if you, we don't really recommend that people do this, doing a beneficiary designation or just leaving your money in your account to somebody else in a will makes the most sense because it doesn't have that added risk of having somebody become a co-owner and essentially have free access to all of your money, and you would have no recourse if they stole all of your money while you're still alive. So co-owners, not the greatest idea. We think it's better to avoid that, but it is a possibility. You can add if you want somebody to get your bank account when you die, you can add them as a co-owner and just hope that they trust that they will not take your money while you're still living. So moving on to our last topic here, reverse mortgages. So what a reverse mortgage is a loan of equity from your home. It is a loan against the equity that you built up in your home. With a reverse mortgage, there are no payments that are due while you are still living in the home. If you move out, that changes. The loan is paid off in full when you sell your home. even if the value of the home is less than the amount of the mortgage. So what it does allow you to do is to get cash out of the equity of your home. But what you're doing is essentially giving somebody, the reverse mortgage company, a claim to your property when you move out of the home or you need to sell it. So you're adding a secured creditor to your home when you may otherwise not have had any, since if you paid off your mortgage, your original conventional mortgage, and you got all the equity, you don't have any other secured creditors on your property. But a reverse mortgage would allow you to get cash out of the home, to get cash out of the equity that you have, and in exchange, you're granting a security interest in the reverse mortgage company, who then has a claim to the property. So what do I need to do to qualify for a reverse mortgage? So all borrowers must be at least 62 years of age. You must own your home, and you must occupy your home as the principal residence for more than 6 months of the year. Your home must be in good repair, and you must have sufficient equity in your home. When does that reverse mortgage need to be paid? It needs to be paid when the last surviving borrower dies, sells the home, or permanently moves from the home. So the reverse mortgages, they come calling when you either when the last surviving borrower dies, when you have to sell the house, or when you permanently move out of the home. So if say an older person gets a reverse mortgage, they take the cash, they use it down, a year or two down the road. Then they need to go. They have healthcare needs. They need to go to some kind of care facility. At that point, the reverse mortgage would say, "Hey, you're moving out of this house into a care facility. You got to sell it. You got to pay back this mortgage, this reverse mortgage." That's how it works. So the advantages of a reverse mortgage: you continue to own your home just like you did before you took out the reverse mortgage. You can get your loan funds through a combination of payment options. So you can, if you want to get your equity in a couple $1,000s a month over the course of a couple of years, you can set it up that way. So you just have this extra stream of cash coming to you each month. The balance on the line of credit can increase over time. Another advantage is existing mortgages are paid off. So if you had a conventional mortgage, they usually get rid of those before the reverse mortgage actually gets put in place, so that whoever that lender is on the reverse mortgage would have sole claim to the property. Another advantage is that closing costs can be paid from the loan proceeds themselves. So there's little upfront cost to you, the homeowner who is taking out the equity in the form of cash. The disadvantages, some of the drawbacks here of the reverse mortgage. So closing costs are not rolled into the interest rate like they are with a conventional mortgage. So they seem much higher than other loans like a conventional mortgage. You may use up the equity in your home, and you may not have anything to leave your heirs. So you may take a reverse mortgage out, get a bunch of cash, use that cash, and then when the reverse mortgage comes calling, there may be no other equity left in the home to go to your heirs. So the people that get your property when you pass away. As I mentioned earlier, if you move out of your home, you are required to repay the loan. So if you take out a reverse mortgage and then have to go to a care facility and move out of your house, you'll be required to repay the loan. The house has to be sold, and your reverse mortgage lender would need to be paid. You're not allowed to borrow for the full value of the home. You can't take out all of the equity. They'll only do it up to a point. I think federal law may dictate what that percentage is. I'm not 100% sure. I don't deal extensively with reverse mortgages. So, but just know that you can't borrow the full value of your home with a reverse mortgage. And if you're older at the time of the loan, the more money, the older that you are at the time of the loan, the more money that you can get from a reverse mortgage. So it does kind of seem predatory, right? That you can get more the older that you are. The idea for the lender's perspective is you're more likely to pass away, move out of the home, excuse me, and then they can come calling for the loan. So those are some of the disadvantages of the reverse mortgage. So the flexible payment options, there are a few different. There's the 10-year payment option where you receive monthly payments from the lender for as long as you live in your home. There are term payment options where you receive monthly payments from the lender for a period of months. It can be a line of credit. You can draw out money as needed until the credit line is exhausted. So you can kind of take out money when you need and not do it kind of consistently. You just kind of hover on an as needed basis. Or you can be a combination. You can combine a line of credit with either a 10-year or term payment. So there are a variety of different options with reverse mortgages as far as how you can get that money out of your house, how you can get that equity out of your house while you're still living in it. So that is all I have. Again, Legal Aid of Nebraska offers free legal advice and forms, including the financial power of attorney and the healthcare power of attorney. They're available online at legalaidofnebraska.org, or you can call the Elder Access Line. Legal Aid of Nebraska also does have a regular access line. That's just a regular legal hotline for anybody who qualifies. That one has income and asset restrictions. But it's just the same thing as the Elder Access Line. It's a legal hotline. You can call in and get free legal advice so long as you qualify. But the one thing to take away here today is that there is free legal advice available to you as long as you are 60 years of age or older through Legal Aid of Nebraska. The phone numbers are there. Our hours are online, so you have to look those up. But you can get free legal advice and some of the basic forms that we talked about here today. I didn't mention this when we did wills, but Legal Aid of Nebraska will create a simple will for you if you call the Elder Access Line. That process is a little more involved. We don't just send you the last will and testament. We'll actually get we have a series of questions to ask you. We'll get the information that we need to draft your will. Then we will put together your will. We will have you come in to review it, and then we'll actually do a signing appointment. A last will and testament has to be signed with 2 witnesses, and you have to have a notary present. So because it's a little more involved to do a last will and testament, we actually do a little more of a full service for a will as opposed to the power of attorney documents. So if you want a simple will, you can contact Legal Aid of Nebraska. If you just want to designate the people that are going to get your property, we can do that for you for free as long as you are 60 years of age or older. Pretty quick and painless. I recommend that you do it. Lots of people take advantage of that service. So I just wanted to make sure that you guys are aware of it. And if you have just any legal issue of any kind and you're 60 years of age or older, you can call the Elder Access Line and you can get free legal advice from Legal Aid of Nebraska. Okay, we may have to direct you if it's kind of outside of our practice realm. We don't have any expertise in it. We may have to direct you somewhere else. But it's a good starting point if you don't know what you need as far as legal services. Contact Legal Aid of Nebraska's Elder Access Line. If you're 60 or older, you can do it for free, and we can either give you the advice that you need, or we can point you in the right direction to perhaps other legal services if you do need it. And that is all that I have. Here's my contact information. So if you want to reach out to me, feel free. My phone number is on there, as well as my email address. We're still working from home, so my email is by far the best way to get a hold of me. I can't give you legal advice unless you actually go through our proper channels through the Elder Access Line, but your case may end up getting sent to me if it's appropriate, and I can give you some legal advice. But the Elder Access Line is staffed by an attorney here. She's been running the Elder Access Line for 15 or 20 years, and our paralegals have at least 10 years of experience apiece. They are great. They have seen all kinds of legal issues. If you think of something, they've probably already seen it. They know the advice to give. So I really do recommend doing it. And if you want to reach out to me, you can do that as well. And with that, I'm going to stop screen sharing.
Hello, Tim. And thank you very much. That's a lot of information to try to digest.
It is.
So I'm just going to ask a couple simple questions in regards to financial power of attorney. Can they sign checks, your bank checks, to pay your bills?
Yes. If you have executed a power of attorney, financial power of attorney, your agent would be able to. That's part of the managing financial affairs. So yes.
And of course, I can see the need that you have to notify your bank so that they know who the person signing your checks will be.
Exactly. Yep. And one common misconception that people have about the financial power of attorney is that like with the healthcare power of attorney, they think that maybe what they're doing when they're executing this document is giving away their ability to manage their own finances. That is not true. You are not giving somebody the power to overrule you. As long as you maintain the capacity to make decisions, you will be able to overrule your agent. Your agent can't say, I don't want you spending your money this way. You say, well, I'm the principal here. You're my agent. You're acting on my behalf. I'm overruling you. You can't overrule me.
Right. But for instance, you're sick, you're in the hospital for a month, and your checkbook's at home and your bills are going to your house. Your power of attorney could sit down and write all checks for all your bills and stick them in the mail for you.
They could, yep. We tell people just have your agent sign it and then just say as POA for so-and-so.
Yep. Okay. Then another question, I think I know the answer to this, but it has to do with the transfer on death deed. If you and your spouse both are on the title to the property, this would not be necessary. Is that correct?
So yes, as to a transfer between a married couple.
Yeah.
Yeah, because once they're both one. So in that situation, husband and wife would both be on the title. If husband dies, the deed that gave them title probably says with rights of survivorship. So
right.
Husband and wife own with rights of survivorship. So if husband dies, wife takes his interest by right of survivorship.
Okay.
So it wouldn't be necessary if in that situation. It's more appropriate for say like a widower wants to deed their house to their child upon their passing. That's where a transfer on death deed would be the most appropriate, because the title would actually not transfer until the person who currently has title passes away, and then that would actually transfer to somebody else.
Okay. And then I know these are a little tricky, these reverse mortgages. What you said was that in the event of the person that's living in the house that has the reverse mortgage, they die. At that point, the reverse mortgage has to be paid off. What if the value of the house, when it's put up for sale, is less than what is owed on the mortgage? Well,
in that case, the lender made a bad deal. Obviously, that's part of the reason why you're not allowed to borrow against the full equity that you have in the home.
Okay.
Lenders want to avoid doing that. But say in your situation that the house isn't, the mortgage is more than what the house is going to be sold for, then it's possible that the lending company could have a claim against the estate for other property. So say somebody had the house and they had a bank account with $30,000 in it. They sell the house, the reverse mortgage isn't fully paid off. The lending company could, in theory, go and make a claim against the estate for.
Okay. That's what I was wondering about. And, like you said, the loan isn't going to be for the full equity in the house. But in some of these crazy real estate markets, sometimes, values can go way up or way down. And so at the time of the mortgage, the value of the house may be quite large, and then all of a sudden after 10 years drop quite a bit.
Yep, sure. Yeah, and that's why the lenders, I think, are pretty cautious with when they do that. They'll let you take out 10, 15, 20,000 or whatever in a reverse mortgage, let you have that cash on hand, and then just maintain their position of saying, well, this house is probably worth $50,000 or $100,000, so we're safe here as long as the market doesn't crash. We should be taken care of. We should get paid back in full.
But the mortgagor only has rights to the amount that was lent, right? They don't have more. They can't take more out of the value of the house than what.
No, they're only owed what they're owed.
Okay. I think there's quite a few misconceptions about reverse mortgages out there.
There really are, and I'm not an expert in it, but we tell people you should really just talk to an attorney before you do it, just so that you know what you're really getting yourself into, because you could think that you're going to be able to take the equity out and your kids will get the value of the house later on, but that might not be the case depending on what happens with the housing market. So you just want to make sure that you're aware of some of the potential drawbacks, because everybody can see the advantages of getting cash out of your home. But you just want to make sure that everybody's fully aware of what's happening with the transaction, that they're going to go through with it.
Right. Oh, and the other question I had was, does your house have to be fully paid off before you take out a reverse mortgage?
I'm not 100% sure on that. I think that it does need to be fully paid off. I think that's more of a matter of the lenders not wanting to be in a second position on your home.
Sure.
Because because that first mortgage has to get, a conventional mortgage would have to get paid. They already have that lien on the house. That would have to get paid first before the reverse mortgage could get paid. And I'm pretty sure that the reverse mortgage lenders are only wanting to deal with people who do not have other liens on the property, like a conventional mortgage.
Right. Okay, very good. Unless you have anything else, I think we're done on this session. And everyone out there who listens to this, if you like it, please like us on Facebook and recommend that your friends listen to it. It's a lot of intelligent information here. Very good. Thanks again, Tim.
Yes, thanks for having me.